Hello, everyone, and welcome to Uncivil Law. For today's story, we have the United States of America versus Yosani Lopez et al. This is a case dealing with a reverse sting operation. In this case, the federal law enforcement conducted a reverse sting, which is where they essentially fabricated a crime and coerced people into committing the crime. Now, coercion and legal entrapment are two wholly different things, so it is very hard to prove entrapment under the case law. But in this situation, the defendants say, well, actually, the United States federal government conducted an illegal operation because they only targeted people of color. So it's a racial discrimination claim. The district court is analyzing. Let's see what the court has to say. By their very nature, so-called reverse sting operations, in which the government creates the illusion of crimes in order to catch would-be criminals, are open to potential abuse, since they are not cabined by the demands of reality, but only by the vagaries of imagination. In this case, the defendants assert there is enough suggestion that the reverse stings executed by the DEA in this district are aimed only at persons of color to warrant discovery on the issue of selective enforcement. This court agrees that some initial discovery is warranted here and possibly more to follow. The defendants in this case are accused of crimes committed in the course of a reverse sting operation conducted by the DEA. First, law enforcement agencies select targets based on recommendations from confidential informants. Come with me, and you'll be in a vagary of pure imagination. An undercover agent or informant then poses as a drug courier and offers the target an opportunity to steal drugs that do not actually exist. Targets in turn help plan and recruit other individuals to participate in a robbery of the fictitious drugs. Just before the targets are about to carry out their plan, they are arrested for conspiracy to commit the robbery and associated crimes. Defendants, who are all men of color, allege that the DEA's use of a reverse sting against them was part of a practice by which the DEA limits such operations in the Southern District of New York to persons of color. Specifically, they assert that the DEA, by using reverse stings only against people of color, is engaging in selective enforcement in violation of the Fifth Amendment's Equal Protection Clause. To succeed on a selective enforcement claim, defendants will need to show that they, compared with others similarly situated, were selectively treated, and that such selective treatment was based on an impermissible consideration, such as race. Because defendants are unlikely to meet this standard without information only the government has, defendants are seeking discovery into the reverse sting. So the scene is set. This is the Southern District of New York, better known as Manhattan. The DEA is conducting a reverse sting. In other words, they are pretending that drugs exist, and they are enticing people to participate in robbing the fake drugs. However, the defendants note that they are all people of color, and suspect this may be part of a practice that goes to a selective and improper form of enforcement. They want discovery. So far, they've not been able to get discovery. But what does the district court have to say about these alleged facts? The Second Circuit has not articulated a framework for evaluating the sufficiency of a motion for discovery on a selective enforcement claim. Because this is the Second Circuit and there is no case law on point, they have to adopt a standard from somewhere else. The government would have the court import the discovery standard for selective prosecution claims articulated in United States versus Armstrong. In Armstrong, the United States Supreme Court held that a defendant seeking discovery on a selective prosecution claim must prove some evidence tending to show the existence of a discriminatory effect and discriminatory intent. This is an explicitly rigorous standard that is premised on the notion that the standard for discovery for selective prosecution claim should be nearly as rigorous as proving the claim itself. So although the claim at issue is selective enforcement because we're going after the DEA and not the prosecutor, the standard the government wants adopted is the same standard that is used for prosecutors. So far, pretty reasonable. Let's see what happened. Accordingly, as now recognized by at least 3 federal circuits, selective enforcement claims should be open to discovery on a lesser showing than the very strict one required by Armstrong. These sister circuits have held that there are material differences between selective prosecution and selective enforcement claims that warrant subjecting selective enforcement claims to a lower evidentiary standard. The Armstrong discovery standard requires defendants to make a threshold showing that similarly situated individuals have not been similarly prosecuted. While such evidence is ostensibly available in the selective prosecution context based on a comparison of arrest and prosecution data, this is not the case in the selective enforcement conduct. Asking a defendant claiming selective enforcement to prove who could have been a target by an informant but was not, or who the law enforcement agency could have investigated but did not, is asking him to prove a negative. So here we can see a difference in standards that emerges from a difference in the facts. In a selective prosecution case, you can point to arrest data versus prosecution data. But in selective enforcement case, you'd have to point to those who are arrested versus those who are not. And how would you get such data? So it's asking you to prove a negative. That's why it's a different standard. While the aforementioned sister circuits have provided convincing reasons to reject the Armstrong approach in the selective enforcement context, they have not provided a clear alternative discovery standard. Nor have they been precise about how much discovery should be permitted. For this court, however, the appropriate standard is that where a defendant who is a member of a protected group can show the group has been singled out for reverse sting operations to a statistically significant extent in comparison with other groups. So if you can show a statistical aberration in the data, that might be enough to get discovery. Furthermore, defendants have provided compelling expert analysis demonstrating that these numbers are statistically significant. According to a rigorous analysis conducted by Dr. Crystal Yang, a Harvard Law and Economics professor, it is highly unlikely, to the point of statistical significance, that racially disparate impact of the DEA's reverse sting operations is simply random. In granting discovery in this case, the court emphasizes that it must proceed in incremental steps. Courts adopting the discovery standard lower than Armstrong for selective prosecution claims have confirmed the importance of granting discovery only in measured steps. The reason here is that law enforcement is entitled to certain secrets and certain protection because of the nature of what law enforcement does. Their methods and their overall practices can be secret. But we need to have discovery. So the way to solve both these problems is by proceeding gradually and only revealing more as the case may deem necessary. Accordingly, and for now, discovery will be limited to the government providing to the defendants, not later than November the 22nd, 2019, all DEA manuals, circulators, protocols, and the like that provide guidance for how and when reverse stings should be originated, and all notes, memorandum, or other investigative materials showing how defendants were identified and evaluated as targets in this particular reverse sting operation. The second category can include such appropriate redactions as in the government's opinion, are necessary to protect the safety of any agent or informant, but unredacted copies must be provided on an ex parte basis to the court. So this is the case of United States of America versus Hosseini Lopez et al. In this case, we learned that the DEA conducted a so-called reverse sting operation in the Southern District of New York, better known as Manhattan. In this reverse sting operation, they pretended that there was a stash house stuffed with drugs. It didn't actually exist. And they enticed criminal defendants to raid the stash house for the drugs that did not exist. Several people were tricked into engaging in this and were subsequently arrested for conspiracy to raid the non-existent stash house. However, the defendants in this case have pointed out that all the people who were arrested were men of color. And they've provided studies from Harvard professors showing that this is not simply a fluke. It is statistically significant that this could not happen by random chance. So there is some evidence to suggest discriminatory intent by the DEA, that they were purposely targeting only men of color. In order to find out further, the district court has ordered limited discovery of manuals, practices, and memorandum to help them discover whether or not this was in fact a discriminatory selective enforcement, and if so, perhaps further discovery will be warranted. But it is a situation where the Southern District of New York has indicated that there's enough to go forward to see whether or not the police were improperly and illegally targeting people because of their race. And that is the end of this story.